come to order. The first item on the agenda is agenda approval.
I'd move for approval of the agenda as presented.
Second.
Been moved and seconded. All those in favor say aye. Aye. Opposed? The ayes have it. We now have a report on the closed session, please.
The board did meet in closed session with its real property negotiator, and looking at the closed session agenda, on the first 4 bullet points, the first 4 parcels, no action was taken in closed session. Action will be taken under the regular session agenda, item 6. On the 5th bullet, parcel 046250011, the board approved an increased offer. On the 7th, the Yokoyama parcel, the board approved execution of a possession and use agreement. On the Isaac Freeman parcel, the board approved an increased offer. The Sessions parcel number 046010052 was dropped from the agenda. And then finally, on the Kim McDonald parcel, the board approved a revised replacement housing valuation. And then item 2 on the closed session agenda, the board did confer with legal counsel regarding 2 potential cases of litigation, eminent domain cases, and no action was taken.
Thank you. Public comment on items not on the agenda. Kim?
I have 3 things to comment on. One of them, I noticed Mr. Fabian is not here. I called and asked who was responsible for keeping up the Palmadesi parcel over there. There is old furniture in the driveway. The house looks very much abandoned, and it does nothing for my safety to keep it up in that manner. And he said he would look into it and it would be taken care of, and quite a bit of time has passed since that. The next thing is that what you're voting on for me as far as the value of what you're going to give me for my house. The numbers you're looking at there, the appraisal was done 2 years ago about, and some of the prices on that, as far as the housing they used, were 2 years old. So you've basically looking at prices of homes from 4 years ago for comparables for my house. There is a third thing, but for right now, I can't remember what it was, and I apologize for that.
Approval of the August 13th, 2015 minutes. I need a motion for that.
I would move for approval of the minutes as presented.
Second.
Been moved and seconded. All those in favor say aye.
Aye.
Opposed? Ayes have it. Review of monthly year-to-date revenue and expenses.
Morning, Mr. President and members of the board. This is the first cash flow report of the fiscal year 2015-16. And we start the year off with a on-hand cash balance of approximately $19.4 million. We accrued the last assessment payment of the year, $191,000, back to the prior fiscal year and did the O&M disbursements out of that. So this new number is a bit of a jump from our number reported last month. There was no significant revenue for the month. And on the expenditure side, we had liability insurance payments. We booked the September and March debt service payments for the 2011 and 2015 bond. We made the last 2 payments of the 2008 bond last fiscal year, so that won't be showing up in the reports anymore. And we had significant real estate transactions in the Southport project and some other minor expenses in the other EIPs as we move forward to close them out. We didn't receive any significant or any state revenue, reimbursement revenue for the month. And total revenues, or total expenses for the month ended up at $4.2 million, and our ending position is $15.2 million for the month of July 2015. And that's the end of the report.
Any questions?
No questions, other than that should be 15, 16 on the
Up.
page 2, year-to-date.
I'll change it, thanks.
Just give you-
No.
Thank you.
You bet.
All right.
Consent agenda.
Consent agenda. Consent,
I have a question on number 7,
all right.
and that is, I guess we agree to this, and it's necessary, and this is something we have to do, but it's just frustrating that it gets delayed, and then delayed again, and then delayed. And we really don't understand why these things are being delayed. The Corps never explains it to us as far as, well, it's being delayed because of this, this, and this. Are there any issues that are going on out there that allow, or not allow, but that force the Corps to continue to delay the GRR? This was supposed to be done a year ago. And it's just frustrating that it keeps going on. I mean, in your discussions with them, do they give you a reason?
Well, Bill, I think you're right. I mean, it's frustrating for staff too. We're in the same situation that we don't necessarily always know why the delays are and, why they take so long to resolve. Some of it has to do with how they look at the region and whatever else is going on in the region, to move things forward. But beyond that, I don't have a whole lot of insight to this, I'm afraid.
Okay, well, I mean, something we have to do, so get this letter of support out and say no more delays.
Well, I think, Greg last month did describe somewhat why it's now into May.
Uh-huh.
And it had to do with issues at the district level. And we got put on this new timeframe. Now it's, the job is to make sure it doesn't slip anymore. We have given away all of our room,
Yes.
if there is a word of bill in Congress
Yeah.
in 2016, if this time slips anymore, we could miss it.
We could lose it, yeah.
We could miss it. We have the SAFCA GRR going on as well.
Mhm.
And between the two of them, I mean, there's enough, political support to make sure we are there. But if they can't get the work done, that's the issue. So I agree with you. We need to continue to insist that they get this completed, especially now that they're asking us to support something that we obviously do.
Right, exactly.
It's-
That's it?
I would just, as part of the approval of the Village Parkway improvements, to point out that the contract or the bid came in substantially below the engineer's estimate for the project. Tykert was the low bid, and I just want to commend, the engineering department for a job well done as far as putting together a bid package and approvals that brought the project in substantially below estimates. So let's hope we get the work done on time and we can move forward to the main levee work. And with that, I would move for approval of the consent agenda.
Second.
Been moved and seconded. All those in favor say aye.
Aye.
Aye. Aye. Opposed? The ayes have it. public hearing on the item number 9 of the agenda. Consideration of resolution 15-0902 authorizing an eminent domain action to acquire real property for the Sacramento River Southport VIP project. Yolo County Assessors Parcel number 046230053-000.
Good morning, President Denton, members of the WSAFCA Board. Today I'm going to present 2 resolutions of necessity for the Sacramento River Southport Early Implementation Project for your consideration. I want to pause here just for a minute and let you know, and the audience know, that we're getting to a point right now where we may be needing more resolutions of necessity to allow the project to go forward and meet the construction timeline that we're anticipating for the next 24 months. Specifically, you just approved the contract for Tykert to go forward with Village Parkway improvements. We do have some court actions that are necessary for that to go forward. But we also have to be mindful of the fact that we're likely going out to bid in January for levee improvements. And in order to meet the court schedule, that we may be bringing other properties for your consideration in the subsequent couple of meetings before the end of the calendar year. So just an FYI. Okay, so relative to these resolutions of necessity today, I'm going to discuss some of the goals of the Southport project, and continue to do an overview as required by the statute. And then I will present the necessary information required for you to make findings for the resolution of necessity. As you know, the Southport Early Implementation Project, Southport EIP, as we've been talking about it, first and foremost is a public safety project. WSAFCA, our overarching goal is to provide 200-year flood protection to the city and its residents with the least amount of harm to private property. Our desire is to design and construct a project that will achieve 200-year flood protection that maximizes the use of local resources. I've gone through this many times. As you know, this all started, following Katrina. There was a new problem identification report that was completed, followed up by an alternatives analysis, identified substantial deficiencies in our levee system, 52 miles, which is protecting the city. Through this process, after the determination, it was decided that we would look at Southport as one of the reaches that has some of the greatest seepage, under seepage and through seepage deficiencies. That happened in 2010. In 2011, a preliminary design report was completed which analyzed deficiencies and solutions to address those deficiencies. Furthermore, that was moved into a final preliminary design report, and that resulted in going from 15% complete design documents to 65% complete design documents. Village Parkway design is 100% complete, and the bid package is now scheduled for release in July. Our project team anticipates that the levee design will be completed this calendar year and out to bid in early 2016, just as I mentioned previously. So prior to the final preliminary design report, staff presented a design decision hierarchy to assist the board in deliberating on solutions that address known deficiencies. So it's a very practical approach where we look at deficiencies, apply different solutions, and try to determine what is the best solution for that problem by minimizing impacts and maximizing benefits. So you may recall there was a combined measure alternative 1. This one included adjacent levee with berms about 200 feet, adjacent levee with cutoff wall. So that was looked at different reaches. This was one of the one of the combined alternatives that was brought to 15% complete. The second one was a setback levee with berms, also extensive berm widths. It also called for a setback levee with cutoff wall and a partial levee degrade. This is moving closer towards our current design. And then the third deliberative step was to also look at fix-and-place solutions with levee cutoff walls and levee berms. Once that was completed, our team presented 2 guiding principles to selecting preferred design alternative. Develop a project that provides the greatest amount of protection to the city as soon as possible and maximize the effects on the community, or minimize the effects on the community while achieving the first objective. The combined measure of adjacent levee with seepage berms, setback levee with seepage berms, and fix-in-place with seepage berm designs were assembled to produce 2 design alternatives. Once that was, both design alternatives were advanced to 15% complete, and at the WSAFCA board meeting in July 2014, the project team presented these 2 design alternatives that included various solutions to address the deficiencies. Alternative 1 included fix-and-place repairs with conventional cutoff wall in segments A and B in the southern end of the project, combined with a setback levee beginning in segment B, through and behind B's lakes, and adjacent to the levee and seepage berm through segment F, and an adjacent levee with a cutoff wall in segment G. Alternative 2 consisted of the same solutions for segments A, C, D, and E, but segment B and F solutions included a setback levee. So at a spring board meeting in that same year, the board approved moving forward with those segments where there was consistency in the various segments. You also asked that staff complete value engineering studies for segments B and F, specifically at the behest of property owners. Value engineering studies were completed in May and August, respectively, and based on the feasibility measures evaluated, the impacts to private property, cost effectiveness, the ability to maximize flood protection, the WSAFCA board directed the project team to integrate the preferred design alternative into the project for segments B and F. Okay. So, as a board, you're charged with making findings for a resolution of necessity. We have to demonstrate that the public interest benefits from the project. The project is located in a manner that's most compatible with the greatest public good, with the least private injury. That the property is necessary to the project, and that an offer has been made to the owner of record. So as I've been up here before, the Southport project, falls between the city's southern limits and the Sac Bank project, 5.6 miles of levee improvement. It's been designed to meet 200-year flood protection, that it's consistent with the guidelines that are provided by not only the U.S. Army Corps of Engineers, but also the Central Valley Flood Protection Board. It will protect over 50,000 people and $4 billion in community assets. And without this proposed improvements, residents and businesses are at risk during a major storm event. So as we talked about, we did a complete evaluation of the system. This is the reach that has some of the greatest deficiencies along this riverbank, and that's why Southport was chosen. It's located in a manner that will be compatible with the greatest public good and still the least private injury. Design selection was deliberative. It considered public safety, engineering requirements and constraints, borrow needs, habitat mitigation, impacts to private property, community fiscal effects, and the ability to provide the greatest amount of good. The property is required for the project. In this particular case, the McDonald parcel is approximately 3.3¼ acres in size. It's located in segment B, right at the transition point from an adjacent levee to a setback levee planned improvements. The 1.57 acres of properties is needed for the levee improvements, including the levee, a seepage berm, and an O&M corridor, and a small area for the offset. In addition, a temporary construction easement is also requested and needed to provide property access to the property from a private road that will be constructed as part of the project. The last finding that has to be made is that an offer has been made to the owner of record. The WSAFCA board has approved numerous offers, the last of which I believe is in May 2015. A complete offer package was organized, assembled, and provided to Ms. McDonald for the property acquisition. That concludes my presentation for this resolution necessity. It's now open for, at your discretion, open for comment.
Thank you. It's open for public discussion.
Good morning, board members. I'm Barbara Brenner, legal counsel for Ms. McDonald with regard to the eminent domain action that you're pursuing on her property. I'd just like to make a couple of points and bring out a couple of facts. It's true Mrs. McDonald has received numerous offers on this property. What has also occurred is each offer has been internally inconsistent and allocated square footage to the home that is not accurate. So we've had numerous offers, all of which have been inaccurate as to the square footage of the home and internally inconsistent. And what I mean by internally inconsistent is in one portion of the appraisal, they'll suggest that the square footage or the acreage is one number, and then in another portion of the appraisal, they'll suggest it's a different number. We have the continuous inconsistency in the most current offer. The other thing that I'd like to point out is, in some instances, the entire acreage was going to be purchased or taken from Ms. McDonald. The most current offer leaves a remainder. In other words, there's the portion of the property that's not being taken. That portion that's remaining, there's serious questions as to whether there's any value left in that remainder property. There's questions as to whether a home can be built because her home will be taken and can't be moved due to its unique construction. So that we have a portion of the property that remains, we don't have any significant value associated with that. Yet the appraisal doesn't recognize that fact. One of the factors is lack of access. Based on that, because of the taking and the way the taking is occurring, there's no longer going to be access. River Road provides access to this current property. Once that road is destroyed and the new levee improvements take place, there's no longer access. There was mentioned by staff that there's going to be a private road. And I would like to like you to seriously consider acquisition of property that is then provided to the property owners. It becomes private land again under that circumstance for only a set period of time. They've guesstimated for a 10-year period of time, when the hope is the developers will come in and create a new public road, is the assumption. I question the authority of the agency to use public funds to purchase property and then give that property back to private interests. And I question in the notion of, is that a gift of public funds? I think that there's a serious legal question in that regard. And I also understand this is not the only piece of property that this is to occur. And what provision of the law does the agency have to rely on to suggest that these various property owners can be forced into a road maintenance agreement and be required to maintain that road in a cooperative manner? I just don't think that's the appropriate methodology to retain access to not only this property, but other properties that are in line for taking. In particular, Ms. McDonald will be obligated to cooperate with others, enter into some sort of road maintenance agreement, and then hope that in 10 years, some new road comes along that's a public road. And that leads to, again, the imposition that, or the situation that the remainder property is actually landlocked. You're taking access away, and you're coming up with some sort of mechanism that doesn't appear to be particularly legal to bring the access back. The other situation is that with regard to the road, there is an allocation of funds for that road maintenance. And again, I question whether that's actually a gift of public funds. Can you give private citizens money to maintain a private road? I'm not so sure you can. And the project proposal is not the least private injury. There have been alternatives suggested to this agency over the years that would indicate you didn't have to get rid of the River Road and that you could do the levee improvements without taking so much property. And that has been presented to you on numerous times, and would like to iterate that there are alternatives. Not only are there alternatives for the levee improvement, but alternatives for the Village Parkway route. Again, the Village Parkway is going through ag land, going through portions of other properties, and not part of the plan is to provide those properties access off of that Village Parkway. If you're going to choose a route for public roadway, then that route should include access to all land that you're taking, but portions of which are remaining. I don't see that as the least injurious to those property owners that you're taking the property from. In addition, the plan is to create large open space and a mitigation bank at a great expense to the current landowners. It's improper to take public land and then sell new open space for mitigation on projects. You're profiting from that taking in response to some unknown demand, and likely the demand from urban development is the assumption. Taking from those few landowners for the benefit of others financially is not a proper use of your eminent domain authority, and is certainly not the least injurious methodology of going about this project. The other thing that's occurring in this project is you're taking riverfront property. In particular, Ms. McDonald's has a very unique property. Her house sits right on the riverfront. You're going to take that riverfront property away from her, create new riverfront property down the road with the relocation, the levee setbacks, et cetera. And all of a sudden, there's going to be this reach of the river that's available for future development and future business development. Again, profiting from that taking. You're taking away one person's riverfront property and allowing in the future development of that property by another is not the least injurious and is not in the public good. You're benefiting, again, from the tax dollars associated with that future sale and operation of businesses at the expense of Ms. McDonald and others. She's not getting compensated at that kind of value. She doesn't have the opportunity to develop her riverfront property, yet you're taking her property and giving that opportunity to others in the future. I suggest that's not a proper use of your eminent domain taking. It appears that the agency is not focused on the significant injury to the property owners along the riverfront. And other riverfront properties that you're taking are going to be impacted as much, if not more, as Ms. McDonald. But specifically, Ms. McDonald is in a unique position with regard to her house location, and she should be able to have the opportunity to remain as a riverfront property and not have to suffer for the benefit of others. And that's what I suggest is happening today. I understand that there's a vision and you want to turn this area into open space, mitigation, new business development along the riverfront. You're assuming future development will create public roads to access properties that are going to be landlocked for the most part as a result of your taking. I think that's speculative. You need to consider building those public roads in the first instance. If you're going to take the land, you should build the road. If you're going to take the property and there's a remainder, you should provide access to that remainder. And if you're going to take property and sell it to developers, you should think of the injury to the property owners, not your financial gain as a result of that effort. If you have any questions, I'd be happy to answer them. I appreciate the opportunity to be heard.
Thank you very much.
Thanks.
Does anybody else like to talk about public hearing items? Paul, you want to respond?
So I'm going to keep my response fairly short. Some of these issues have just been brought to my attention. However, we don't necessarily agree on everything that Ms. Benner just presented. We do believe that providing private road access is a legitimate use for the project to make sure that parcels do not remain landlocked. As you know, we went through a deliberative process to determine what was the need for the project. What was presented today in this Ron hearing is what is needed for the project in regards to Ms. McDonald's parcel. There is no intention right now, there's no intention that I'm aware of to acquire property and then resell it to developers for other development purposes. That's just not the case. So those are my responses. Like I said, I want to keep it concise to what I think are the issues at hand.
Well, I'll make some comments. I don't have anything directed to Paul. You know, this is the hard part of the process. You know, the people that were living along the river, and there's a lot of emotion to it all. But in this case, you know, I don't think we have any alternative as far as Ms. McDonald's property. If I understand right, originally we were going to make an offer for the entire parcel. It was her decision to remain just the portion, as far as I know. And likewise, the idea of open space and a bank and whatever happens in the long term with that property is not the issue with her property. I mean, it's regardless of what alternative we ever would have chosen for to make the necessary improvements for our 200-year flood protection along there, her house was going to be a victim of that. So in that case, I mean, there'll be issues that sounds like will have to be worked out down the road, but I'm in support of this resolution today in order to move forward with acquiring the property.
Make that into a motion, and I'll second it.
It's a motion.
Second.
Been moved and seconded that we approve the resolution. All those in favor say aye.
Aye.
Opposed? The ayes have it. Resolution is passed. Let's see.
It follows, keeps going.
Item number 10, is that?
Yeah, we're doing that.
You want to do that one?
Yes.
Item number 10 on the agenda is a public hearing consideration of Resolution 150904, authorizing an eminent domain action to acquire real property for the Sacramento River Project EIP program, Yolo County Assessors Parcel 046-270-034-000. That is the Freeman property.
That's correct. President Denton, members of the board, I'm here to present Resolution Necessity 150904. Before I move forward, there was a small typo in the resolution. It was carried over from a previous resolution. That's since been corrected. Previously it said forecast land investments. That now says Freeman, or Mr. Isaac Freeman, where necessary. I'm not going to deliberate on the background. I've already gone through the background for the purposes of this resolution necessity. I'm going to focus on the findings and what those findings are in terms of Mr. Freeman's property. Again, the need for the project is in the public interest. The project is planned and located in a place that is most compatible with the greatest amount of public good with the least amount of private injury. The property is necessary for the project, and the owner is an offer is made to the owner of record. So again, this is in Southport. This particular property is essentially right in the middle of the project footprint, just south of Davis Road. The necessity for this project is the fact that we have a deficient levee system, and specifically from Sac Bank all the way to the southern border is sufficient deficiencies that can only be met with fix-in-place adjacent and setback levee solutions. We have a design to implement those solutions to achieve 200-year flood protection, and without moving forward, residents and commercial businesses continue to be at risk. The project is planned and located in a manner that will be most compatible with the greatest public good and leave private injury. As you know, this project affects a number of property owners right along the Sacramento River. This is a project that will significantly improve our entire system. We've evaluated numerous designs to achieve and meet the goals and objectives of the Central Valley Flood Protection Boards and the Army Corps of Engineers requirements. And through your process, you considered all of the following factors: public safety, engineering requirements and constraints, the impacts to private property, mitigation requirements, as well as the fiscal effects and WSAFCA's ability to provide the greatest amount of benefits with the least amount of harm, and using existing resources. Mr. Freeman's property, as I already mentioned, is located at Davis Road. It measures approximately 4 3/4 acres in size. This property is located at the corner of Davis and the future Village Parkway. Just over 1 acre is needed for levee improvements specifically. There is also a temporary construction easement needed along the eastern boundary of his property for the construction of Village Parkway and specifically for drainage. And the last findings that you need to know about is that there has been an offer made to Mr. Freeman. WSAFCA approved an offer for acquisition in January of this year. A complete packet has been organized, assembled, and provided Mr. Freeman, and negotiations have been ongoing. That concludes my presentation for this particular resolution.
Anything else?
We're going to open for public comment.
It's open for a public hearing. Anybody have any comments? Public hearing is closed. We will entertain a motion to,
Well, again, it's necessary for the project, so I would make the motion to approve Resolution 1509-04.
I'll second it.
been moved and seconded that we approve Resolution 150904. All those in favor say aye.
Aye.
Opposed? The ayes have it. WSAFCA project update.
Thank you, Mr. President, members of the board. Few important updates for you and the public to understand. The Army Corps of Engineers has issued a 404 permit for the Rivers erosion site. I'm happy to report that the contractor, Nordic, has mobilized and work is to begin next week. Also of note, we received word from our program folks at the Department of Water Resources that the funding agreement has been executed. So we're waiting to receive copies of an executed funding agreement. That means that we will, with meeting a couple of other requirements, we will be seeking reimbursement to the proper cost share for design costs, specifically right away. So up to this point, they've been cost sharing at a 50%. This will bring that up to an 80+%.
And where exactly is a 404 permit being utilized? The exact location?
It's the ditches, the RD 900 ditches that fall within the alignment of
It's the
Village Parkway.
ditches.
Yes, it is.
Okay.
This past year, you approved Task Order 4, Amendment 5 for HDR engineering. This is just an informational item that an amendment has been made, which you've already authorized for time. There's no additional funds, so we just wanted to make you aware of that. Staff have been meeting with property owners to try to work out some small issues sometimes with access, for instance. So Toby met with a property owner this past week along with BRI to try to talk about the entrance to the redefined entrance to the property. So they're working through issues of that nature. You may have noticed that we have another person over next to Chelsea. It's Marianne Greer. Marianne has been being trained by Chelsea. Chelsea will be out on maternity leave, perhaps as early as the next meeting. And so Marianne will be assisting us over the next 5 to 6 months to get the board agenda package ready and other back office items that we have going on. 2 other things that you should be aware of. We prevailed twice in court in the last month. We received a possession and use agreement for construction across the Victoria Yokoyama's parcel for the Village Parkway approval. So that tentative judgment was issued the day before, and there was no challenge to that judgment. Most recently this week, as you may recall, there's a property that is in bankruptcy. The bankruptcy judge has is not enforcing a stay, and we are allowed to proceed forward with making an offer for what we need for the project in the name of public safety. And to round out the announcements, I want to remind everybody that next month is Flood Preparedness Week. That happens October 19th through October 23rd. Crocker & Crocker is working on a number of different strategies and events. So there's going to be a high school student competition to come up with a flyer for the Emergency Operations Center. There is a game, Plan, Pack, Protect Challenge that's being developed. So we'll see how that rolls out. And then we'll have another poster design contest that'll be going on with the elementary school. So you can anticipate that will be coming forward in November, probably, the results of that. So just wanted people to be aware of that. That concludes my report.
Questions? No, nothing on that, but I saw in the newspaper recently where people were not renewing their flood protection and flood insurance rates and policies because of the drought. I mean, I understand their thinking, but at the same time, I would really like to stress to the television audience, whoever watches this, I have no idea what your life is like. But, anyway, one thing leads to another, and you should have flood insurance. I mean, it's not that expensive if there is an event. And everybody's talking, or you see the news reports and things about El Nino or whatever else coming up in this coming winter. And it takes some time to put that flood insurance policy in place. So I would just strongly advise that our community get behind and look at flood insurance and start renewing the policies that you let go by. So anyway, that was just a comment that I saw, and I was concerned about it because we have let those policies lapse. A number of people have. And it's throughout the entire region, so it's not just West Sacramento, but at the same time, if we can get West Sacramentans to pick up their flood insurance, I think it's a wise investment. Thank you.
I agree, good advice. And
Very good.
there's a advantage to keeping that policy consistent if rates ever do change.
That's right.
So,
Yes, definitely. Anything else? That's it. Meeting